Good afternoon, ladies and gentlemen. Welcome to the HKU Boase, Cohen, and Collins Criminal Law Lecture of 2021. My name is Professor Simon Young, and I'm the Associate Dean for Research in the Faculty of Law, University of Hong Kong. This is the fourth criminal law lecture in a series that started in 2017. And as many of you know, this is one of the highlights in our academic calendar. And in the past, when we have held this lecture, it has been held in our large moot courtroom, which seats almost 300 people. And normally we would have the entire room full. And in that same tradition, albeit online, today I understand that we have more than 400 people who are registered for this event. So we're very pleased to see the interest in both this lecture and in the topic of criminal law. Now, the law firm who is partnering with us, Boase, Cohen, and Collins, as many of you will know, has a very strong focus in criminal law. And I'm going to call upon the senior partner, Mr. Colin Cohen, to give some opening remarks and also to introduce our distinguished speaker today. Mr. Cohen.
Ladies and gentlemen, on behalf of our firm, may I welcome you all to the fourth Hong Kong U Boase, Cohen and Collins Criminal Law Lecture. We are delighted to continue our association with the Faculty of Law, and my thanks go to the Dean, Professor Fu Waling, and his team for their outstanding efforts in staging this event. We are greatly honored to have with us today Lord Ken Macdonald, Queen's Counsel, a founder member of Matrix Chambers in London. His experience as Director of Public Prosecutions from 2003 to 2008, was the first prominent defense lawyer to be appointed to the post, has helped give him the unrivaled insight into the sensitive issue of criminal risk and associated prosecutorial responses. Lord Ken Macdonald has been to Hong Kong on numerous occasions. He's appeared and he's been admitted to the courts here in Hong Kong and has appeared before the Court of Final Appeal. He also was involved in a long time here, a month or so, when he was helping and assisting the Department of Justice, the then DPP Kevin Zervis, as he then was, who is now a Court of Appeal judge, asked for his assistance and input in assessing the way in which the DOJ here in Hong Kong operates. As well as all of this, he was warden of Wadham College at the University of Oxford for 9 years, and he only stepped down recently. He's been variously described as the senior statesman of the criminal bar and Premier League, completely fantastic. He was knighted in 2007 for services to the law and appointed to the House of Lords in 2010. I could spend a great deal of time listing Ken's stellar achievements in the world of law, but it's best that we hear from the man himself. Ladies and gentlemen, with great pleasure, I welcome Lord Ken Macdonald to give us the fourth lecture. Thank you, everyone.
Well, thank you very much indeed for that very generous introduction, Colin. Can I say what an honor it is to have been invited by your firm and by Hong Kong University to give this very prestigious lecture, and I greatly admire some of the individuals and know well some of the individuals who've given this lecture in the past, Claire Montgomery and Jeff Robertson and others. And as I said, it's an enormous honor. So thank you very much for inviting me. And I'm very glad to be in Hong Kong, at least virtually. I'm sorry I can't be there in person. It's a place that I'm enormously fond of and have many friends and colleagues in Hong Kong. Let me start by explaining why I've chosen the topic of free speech in connection with universities in particular. When Colin rang me up and invited me to give this lecture, He made it very clear that I could choose any subject I wanted, so long as it had some connection to the law. Well, I think free speech does have some connection to the law, and that's my topic. But why free speech? Why in universities in particular? To answer this question, I need to say something about what universities are, or at least should be, in free societies. I also need to address a fault line, which is the shifting line between free speech and criminal speech. And what about offensive speech? What attitude should universities take to speech that some of their members find offensive for one reason or another? Now, mainly, since I'm a British lawyer and the former head of a UK education institution, I'm going to be discussing these issues firstly in connection with some recent UK security legislation and the impact of that legislation upon the health of free expression rights in United Kingdom universities. But secondly, I'm going to be considering what some people see as an increasing process of self-censorship in our universities. The ways in which some members of US and UK universities in particular seem increasingly keen on policing what may and may not be said, what views it's tolerable to express, and which views must be left unsaid. And I'm going to consider what impact those sorts of attitudes may have on academic freedom. But the right to free expression and academic freedom are, of course, universal values. And I've no doubt that what I have to say will have relevance and application to Hong Kong as well, perhaps particularly at the moment. Let's start with universities. Primarily, universities are places of exchange, of intellectual exchange. This is true in their research function and in their teaching function. Both teaching and research involve exchange, including the exchange of ideas and learning. It's self-evident that within this process, disagreement is not just to be tolerated, it's to be positively encouraged. This is because without the potential for disagreement, any intellectual exchange amounts to no more than empty words. But this means that for intellectual exchange to be of real value, it must be, so far as it can be, unfettered by external controls. An intellectual inquiry that's fettered, whether by some external mechanism like political influence, or by some internal self-censorship imposed by teachers or students on account of any particular values they hold or particular views they have of the world, is less likely to tolerate disagreement and more likely to foster conformity, hegemony. For this reason, this sort of intellectual inquiry is less likely to approach the truth. Seen at their most basic level, these sorts of controls in each category exist to determine, to preordain what the truth is, how it should be expressed, even before the discourse has taken place. Their whole purpose, however nobly they're described, national security, patriotism, being kind to people, however innocuously they're presented, their purpose is to try and influence, even to direct, where an inquiry should land and what its result should be. But we know where this process leads, and it isn't anywhere good. Not everything is relative. Some things are true, and some things are not true. Some arguments are valid, and some arguments are not valid. And of course, not all opinions are of equal value. Only intellectual dispute, sometimes bitter, disagreement, sometimes fierce, can begin to separate that which has value from that which has none. One of the things I do outside my academic and professional life is to chair the Orwell Foundation in London, which, among other things, awards Britain's leading prizes for journalism and political writing. In his great novel, 1984, which I'm sure many of you are familiar with, the British novelist and commentator George Orwell, in whose honour the foundation is named, imagines a world in which oppression is fueled by surveillance and mind control. In everyone's apartment in his imagined world, there's a screen on the wall which broadcasts propaganda continuously. But it watches too, all the time. The dictator, whom Orwell calls Big Brother, is watching you, posters proclaim everywhere, and he is. His face is on every building and on every wall. It looks out at you everywhere, watching you. Orwell paints a personality cult from hell. And it's precisely because he knows everything about you that Big Brother is so powerful. He knows what you believe, he knows what you do, he knows where you are. His goal is to know everything. As it happens in his novel, Orwell imagined the sort of technology that might make state power of this magnitude possible. 80 years on, that power exists in scary reality. We live with it, and we live with much worse. In the novel 1984, Big Brother, of course, is a code for the state, a particularly oppressive state imagined by Orwell in 1949 when he wrote his masterpiece. This state is a futuristic dictatorship, and it's defined by a lack of empathy and by a complete absence of humanity. In Orwell's imagined hell, life has become a machine and human beings are no more than insignificant cogs. Their life has no independent value. Now, I think that in writing this book, even in the aftermath of the world's great victory over fascism in the Second World War, Orwell was making two linked propositions. Firstly, that human progress is uneven. And secondly, in consequence, that if we don't take care, things can get worse as easily as they can get better. Critically, Orwell believed with passion in free speech as a primary means of winning, entrenching, and enhancing the civil and political rights that make life bearable. It was precisely the absence of free speech in his imagined state that made life there so inhuman. This absence was the basis for everything else. But Orwell was not naive. He was not so foolish as to believe that articulated speech on its own had intrinsic value, or was sufficient on its own to secure the human condition. He too knew that some things are true and some things are not true, and that it was important to be clear about which was which, and then to be loyal to the truth. In other words, not to use your free expression rights, to use your free expression rights to speak the truth, not to tell lies. Orwell believed that without a search for truth that's underpinned by free speech, there can't be any rights or any progress, just ignorance, which brings repression and reaction as inevitably as night follows day. He also understood that the bigger the lie, the easier it can be to swallow, that if politicians speak without regard to the truth, injustice is bound to come, along with inequality and unfairness. This is not a point about the merits of particular political ideologies. It's a point about the purity of public discourse. No good will ever come from political leaders for whom truth and untruth are literally meaningless concepts. And we see this in very clear terms around the world. A refusal to privilege truth over lies should be anathema to universities, the opposite of everything that they stand for. Universities should resist lies. So fundamentally, Orwell's passionate commitment to freedom of expression was framed within his equally passionate belief that public discourse should be moral, just as discourse in universities should be moral. If demagogues can persuade people that nothing is really true, or at least that it's impossible to distinguish between true facts and false facts, this destroys people's confidence in what is real, and it opens the gates of power to liars. Orwell showed how ugly, unfair, and violent a world ruled by liars could be. So I believe the most powerful revelation in Orwell's greatest novels, Animal Farm and 1984, is that the ignorance and lies that he portrays in his dystopias are only possible when speech is not free. What's inescapable in his narratives is the first thing that's taken away from victims of injustice is their right to speak freely. The ignorance and lies he portrayed all amounted to this: the ignorance of those who are not free to speak on the one hand, and on the other, the lies of those who prevent them from doing so precisely in order to keep them ignorant. The ultimate circular abuse of power. So tonight I want to argue that not only that free speech is the lifeblood of a university, but also that threats of the sort I have described, external political influences on the one hand and internal censorship on the other, are to be taken seriously, and if they exist, should be resisted. Let me do this through two prisms. Firstly, through the prism of the UK government civil society anti-terrorism programme known as PREVENT. And secondly, through the prism of a new kind of student activism, particularly in the US and the UK, that seeks to set up stricter and stricter parameters about what is and what is not acceptable speech, what you can say, what you mustn't say, and who's entitled to say what. Again, I'm sure these issues, these problems, the challenges they raise resonate today in Hong Kong as much as they do in the UK and the US. With that background, let me turn to the PREVENT programme. I think it's safe to say that this programme in the UK was born of a fear of what's sometimes called the enemy within. The fear that a group of fellow citizens, usually of a different race or religion, are alienated in some way from the state, whether because they're hostile to it or because they've been excluded from it. It doesn't really matter. The program itself, the PREVENT program, is a civil society program which is designed to require civil institutions to have procedures in place to identify those of their members who might be at risk of being drawn into terrorism, and then to refer those people to government de-radicalization programs. And these programs would include counseling and other practical forms of support. So no criminalization, but state intervention nevertheless. And obviously the stigma of having been so identified. Now, I think it's fair to say that the PREVENT program as a whole was designed with the very best of intentions. After all, terrorists do target vulnerable people as potential supporters and actors. And it's perfectly reasonable to see it as the government's responsibility in a democratic society to intervene to protect those who might be subject to this sort of pressure to develop a program of identification and assistance in these cases. And we know in the UK, there are British people living in our own country who are sympathetic to terrorist causes. London experienced the direct result of this on the 7th of July of 2005, when bombs were placed on the underground railway system and dozens of people were murdered. And much more recently, dozens of young people were murdered in Manchester in northern England, and an Islamist suicide bomber attacked a pop concert. We're also clear that the category of threat that we face is actually quite new. Of course, terrorism isn't a new phenomenon, but this form is different to the forms that we have been used to in the past. It emanates from unaffiliated, loose-knit networks of individuals who think they're having a conversation with God. These communications apparently incline them to the use of indiscriminate violence. Indeed, they seek as an absolute primary tactic civilian casualties of the broadest and crudest kind. The fact that their ultimate goals are global in nature and utterly unattainable only allies their dangerous unpredictability. That said, we need to understand an important additional risk carried by this frightening threat of violence, and that is to say that it's designed to tempt responses from us that betray precisely those values that we're supposed to be protecting in the face of terrorist violence. So where does the UK PREVENT program sit in this? Does it respect rights, including free speech rights? One central problem with it has been that because the terrorist threat we faced prior to the creation of the PREVENT program emanated almost exclusively from young Muslim men, a strong perception swiftly developed within the Muslim community that PREVENT was a discriminatory policy directed only at Muslims in order to curtail their political activity through various mechanisms of surveillance and control. In this community, it created a good deal of ill will towards the state, which presumably hadn't been the government's intention at all. But we should acknowledge that this may have been a problem of implementation rather than a flaw in the policy itself. I can see why in some sectors of society, some carefully designed form of PREVENT-style program might seem appropriate. As I say, governments do have responsibilities towards vulnerable people who may be more easily drawn by bad actors into terrorism, and they certainly have a duty to protect the wider community from indiscriminate violence. But the question for this afternoon is whether the PREVENT duty, as set out in UK legislation, is appropriate for universities. Maybe appropriate from some other universities. Can it work from some other institutions? Can it work in a university? Section 26(1) of the UK's Counter-Terrorism and Security Act 2015 imposed for the first time the PREVENT duty on universities. And I want to explain why I think in the university context, this development represents a threat to free speech, even to academic freedom. And I want to do that by considering precisely what the PREVENT duty required of institutions of higher education and what its implications were in universities. A situation in which universities were asked to become part of an apparatus of surveillance. Now, just like in other civil society institutions, the PREVENT duty required universities, quote, to have due regard to the need to avoid people being drawn into terrorism and to have policies and practices in place to achieve this. In particular, universities would be required to identify and to deal with behavior that the PREVENT guidance described as non-violent extremism. In the face of acts of so-called non-violent extremism within their institutions, universities would have a statutory duty to intervene and to exercise some limiting influence. This could include banning from campus speech that might appear to come within such a category, or even referring students expressing so-called non-violent extremist views to the authorities for de-radicalization. Statutory guidance also required universities to check in advance of speaking events that external speakers were not likely to express such non-violent extremist views, and if they were, to take steps to limit the speech to content that wasn't extremist, or to cancel the event. Those of you who are university administrators will appreciate how difficult such a task might be. It would mean vetting what people were going to be saying, external speakers, in advance of their saying it. So what was it that the UK government regarded in the context of this legislation as non-violent extremism to mandate, to trigger these sorts of rather draconian interventions in speech rights by university authorities? Well, the statutory guidance that sat alongside the Prevent legislation said this, and I'm quoting: "Non-violent extremism is activity that represents vocal or active opposition to fundamental British values, including the rule of law, individual liberty, and the mutual respect and tolerance for those of different faiths and beliefs." Now, I suppose that at first glance, this might seem very reasonable. It looks quite like an apple pie list. Who could object to a policy intended to protect the rule of law, individual liberty, and mutual respect and tolerance for different faiths and beliefs? Surely we'd all like to live in a state like that. But often when states come out with this sort of phraseology, it's quite a good idea to look behind it and see what the implications of implementation would really be. Because within the context of a university, in my judgment, the government's insistence that it would be an act of non-violent extremism to express vocal opposition to such values is hopelessly unworkable. In fact, I think it's sinister. Quite inevitably, such a definition imposes on universities and members of universities policies that either directly interfere with free speech or have the foreseeable and actual effect of chilling the exercise of free expression. In particular, and critically, this definition requires universities to police, even to ban, activities and speech that are completely lawful and no more than controversial, if they're even that. Let me explain. In Europe, freedom of expression is guaranteed by Article 10 of the European Convention on Human Rights. But Article 10 doesn't bestow an absolute right. An example of an absolute right granted under the European Convention is Article 6, the right to a fair trial. That's for obvious reasons. In a democratic rule of law society, there are simply no circumstances under which a trial may lawfully be unfair. But Article 10 is different. It permits exceptions to the right to free speech, but only where those exceptions are prescribed by law and necessary in a democratic society for a specified purpose. These purposes include the interests of national security, territorial integrity, public safety, the prevention of disorder or crime, protection of public health and morals, protection of the reputational rights of others, and preventing the disclosure of information received in confidence, or maintaining the authority and impartiality of the jury. So some very obvious exceptions. It's the fact that Article 10 is conditional in this way that makes it acceptable and lawful for the UK to have a good deal of legislation that effectively limits the right to free expression under the law. For example, Article 10 permits us to have legislation that outlaws the incitement by speech of racial hatred and the encouragement by speech of acts of terrorism. These prohibitions are said to come within the exceptions which are set out in the rubric of Article 10. Speech inciting religious hatred is also prohibited under UK law. This is an obvious and categorical limitation on free speech, but it's regarded by our Constitution as a proportionate and necessary limitation in our democratic society and entirely consistent with the terms of the European Convention on Human Rights. But the history of this legislation illustrates very nicely the point I'm making about the threat to rights represented by Prevent in the Academy, and illustrates the care we should take in addressing this threat. So let me say a little bit about the passage of this legislation through Parliament. The Racial and Religious Hatred Act in 2006 came into force in the United Kingdom on the 1st of October 2007. When this legislation was first mooted, there was a good deal of concern. For instance, some people believed the legislation would prevent comedians making jokes about religion, or atheists from mocking belief. On the other hand, some believers were pleased, thinking the statute would protect their particular religion from insult. In fact, we've ended up with a position that, entirely consistent with the existing law prohibiting incitement to religious hatred, British people remain perfectly free to insult any religion, to make jokes about any religion, to mock any religion. So how has this come about consistent with the legislation? Well, it's because the UK Parliament took a very strong stance in favour of protecting freedom of expression when the 2006 Act was passing through Parliament. It applied the Article 10 balance, but it tilted it firmly in favour of free speech. It did this because it felt that belief systems deserved weaker protection in law than, say, racial identities. Parliament felt that questioning someone's belief was categorically different to questioning their identity. People should be willing and prepared to defend their beliefs, and religious believers should accept the right of others to challenge those beliefs. This becomes evident if we look at just a few of the Act's provisions. Firstly, under the Act, the words, behaviour, or written material justifying a prosecution for the incitement of religious hatred must be threatening. This law did not cover language that was simply abusive or insulting, unlike the law criminalising racial hatred, where abuse or insult are sufficient to trigger prosecution. Secondly, the words, behaviour, or written material must be intended to stir up religious hatred. This is a much more specific and higher test than the condition for prosecuting incitement of racial hatred, where it's sufficient if the words complained of are likely to stir up hatred. Strikingly, this means that even abuse or insults which are positively intended to stir up religious hatred may not be prosecutable under this law. Or they may be prosecutable, it's true, under other laws. Thirdly, and perhaps most significantly, the 2006 Act contains a very broad exemption to protect freedom of speech. It states that the offence cannot be used in a way that prohibits or restricts any discussion, criticism, antipathy, dislike, ridicule, insult, or abuse of a religion or its beliefs or practices. Now, there is no way this law would have got through Parliament without this list of exemptions, which was forced on the government by opposition parties and backbenchers and widely supported by the community. There was a clear desire on the part of parliamentarians to interfere with free expression as little as possible in the field of ideas. People can be expected to face robust challenges to their ideas, which they develop themselves and which can change over time, particularly in the face of contest or argument. Who here this afternoon has never changed their mind in the course of an argument? If you haven't, it may indicate that you're not a very thinking person. But having your ideas challenged is different to facing an existential challenge to, for example, your racial or ethnic identity to your existence, which is who you are and which cannot be changed. I expect most of us would welcome this distinction, but the prevent duty fails to make it. Prevent is not directed in universities towards the upholding or the reinforcement of the criminal law. Its purpose is much deeper and much broader. As we've seen, it requires universities to police, even to ban, speech which is completely and without question lawful. That is to say, speech which, according to the definitions I've given, does not amount to any breach of any criminal law relating to speech, which is yet, under the government's definition, an expression of non-violent extremism. Vocal or active opposition to fundamental British values, including the rule of law, individual liberty, and the mutual respect and tolerance for those of different faiths and beliefs. When I was a young undergraduate studying politics, philosophy, and economics at the University of Oxford, one of my economics tutors was a Marxist. He believed that the rule of law is a class construct designed to keep one class, the bourgeoisie, in power over another, the proletariat. Should such views really be forbidden in university? And if such a rule was not to be applied to him, a highly intelligent white male academic, why should it be applied to a young Muslim woman in respect of another part of the definition? Plato, the great Greek philosopher, thought democracy was an abomination. Would he be banned from speaking in a British university in 2021? And respect for others religions, can I really not be rude about religious belief in a British university, even though we've seen at Parliament's determined insistence the criminal law permits precisely that? In truth, disrespecting other people's religious views seems the weakest of triggers for speech limitation. Controls of this sort are bound to close down swathes of entirely legitimate and appropriate discourse and function. British intellectual history is littered with examples of great intellects ridiculing religious belief, questioning the bona fides of English law and the value of British institutions. These include famous Oxford professors, some of them living and working today, of whom the university is very proud. And why not? To seek to curtail such discourse would surely be intolerable in the context of an institution of higher learning. Ironically, to take such a step would surely be inconsistent with those very British values the government seems so concerned to uphold. Let me mention one other piece of United Kingdom legislation, Section 28C of the Higher Education and Research Act of 2017. In the clearest terms, it refers to, quote, the freedom within the law of academic staff at English higher education institutions, 1, to question and test received wisdom, and 2, to put forward new ideas and controversial or unpopular opinions without placing themselves in jeopardy of losing their jobs or the privileges they may have. But how are professors to question, to test received wisdom, or to put forward new ideas or controversial or unpopular opinions, if they're also to have a role in policing precisely similar speech on the part of their students? In this context, it's worth remembering one other thing that George Orwell said about free speech, that its whole point is that it bestows upon us the right to say things that other people don't want to hear. And the courts, both in the UK and the US, have repeatedly made clear that the right only to anodyne speech, the right only to say that which does not offend, is not a right worth having or exercising. So the courts found it was not criminal for Abu Hamza, a notorious British terrorist now serving a life sentence in a US jail, to describe Britain, the country in which he was living, my country, as a toilet. He was entitled to say that. He was entitled to say that it was corrupt and without a moral conscience. He wasn't entitled to say the killing of non-Muslims is justified in any circumstance. The European Court of Human Rights recognized this distinction very clearly. In Lingens against Austria, the court was at pains to highlight that political speech, for example, should receive a high degree of protection because of its importance in maintaining democracy, and that includes the political speech of students. In Handyside versus the United Kingdom, the Strasbourg Court, the European Court of Human Rights, stated that freedom of expression constitutes one of the essential foundations of a democratic society, one of the basic conditions of its progress and for the development of every man, and we might add, woman. In vehemently protecting freedom of expression, the court held in the Handyside judgment that Article 10 of the European Convention of Human Rights, quote, is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but to views that offend, shock, or disturb the state or any sector of the population. The court went on to state that without this kind of pluralism, tolerance, and broad-mindedness, there can be no democratic society. Well, it could hardly be clearer. It's obviously a very big mistake to allow the state a role first in determining questions of taste, and secondly in devising punitive processes to deal with those who in its eyes fall short of that standard. There are things it may not be prudent or wise to say, things it may be irresponsible and unhelpful to say. There are plenty of things that it's plain nasty to say, but the debate about what idea it's sensible and wise and polite to express in a globalized world where people of different cultures live so closely together is quite separate to the issue we're considering this evening. So what has been the effect of Prevent, and has it, as some argue, had a chilling effect on free speech in UK universities and on political activism? My impression at my own university, the University of Oxford, is that many students, rightly or wrongly, feel that their rights to express and act upon their political views have been circumscribed by the incorporation of Prevent into the university environment. Some of this inhibition may well be imagined, but that doesn't make it any less real in terms of its chilling effect. And my impression appears to be borne out more widely by recent research, which seems to demonstrate that Prevent is causing many Muslim students in particular to change their behavior by self-censoring or disengaging from campus political life. and their studies for fear of being stigmatized or labeled as extremist or subjected to discrimination. The same studies showed that Prevent produced wariness among Muslim and non-Muslim students about participating in research on religion, freedom of speech, and campus life. And this would suggest that Prevent is not just a problem for Muslim students. The former director of the School of Oriental and African Studies in London told Parliament, quote, "There's a sense on our campus and among a lot of our students that they're operating in an environment where they feel under particular scrutiny, whereas students who may be Muslim or come from ethnic minorities of a particular political view, that they're under additional scrutiny as a result of that." It's for all these reasons that when the Prevent legislation was passing through Parliament, through the House of Lords, David Pannick and I put down amendments, Lord Pannick and I put down amendments requiring universities in implementing the Prevent duty to have particular regard to their pre-existing statutory obligations under the Education Act of 1986 to secure free speech for their students, staff, and visiting speakers, and to protect and secure academic freedom. Eventually, the government accepted this position, and this means that it's now possible to see the implementation of the Prevent duty as something that should occur strictly in the context of the protection of existing rights, such as free speech rights. So in the University of Oxford, we decided the duty and our policies around it could only safely be implemented in the context of those existing rights and should always be seen as subordinate to them. Above all, our students and academic staff and our visiting speakers must retain and have confidence in their right to free expression, to autonomy, the right to hold, express, and act upon political opinions within the law, the right to be free from discrimination, and the right to equal treatment under the law. Each of these rights was potentially impacted by Prevent, but we felt that so long as our policies under Prevent were always subordinate to and consistent with these pre-existing rights, we could limit the damage to our academy. Perhaps we succeeded, but the government has never updated the Prevent guidance to take account of this approach. It's never altered the definition of British values, and that means potentially the chilling continues. Worse, the risk of over-compliance on the part of universities continues to exist. And there seems little doubt that institutions less wedded to fundamental rights or simply less thoughtful could find themselves consistent with a more compliance-based approach to the legislation, losing something intrinsic to a university's true culture. That, I believe, is a genuine threat to British values. And another is this. By its nature, the Prevent programme implied that universities should develop ongoing relationships with the security services, in which they would have ongoing conversations about the political views and activities of their students. Now, I understand that if a university becomes aware that a student is becoming involved in genuinely dangerous extremist activity, it has a duty to society not to remain inactive in the face of that threat. It has a duty, in short, to involve the authorities. But that's a very different thing from saying that it's part of a university's intrinsic role to monitor the political views and activities of its students and to have an ongoing dialogue with the security services about this. This seemed to me to run the risk of changing the relationship between the university and its students in dangerous ways. The university is no longer simply an educator. It becomes part of a surveillance structure in ways that are bound to impact on the confidence with which its students feel free to express their opinions. A change of this sort will inevitably impact upon free expression within the academy and upon academic freedom. You can be a serious academic institution, respectful of the rights of your members, or you can be a part of the surveillance state. You can't be both. Let me turn now, much more briefly, I hope, to what I take to be the second challenge to free speech in certainly British and North American universities. And this is a threat that paradoxically emanates from some students and from some teachers themselves. It's the increasing desire, most prominently expressed in the UK and the United States, but increasingly in France and Germany and other European countries, on the part of some students and teachers to police the bounds of acceptable speech, to set bounds on what is permissible to say and not to say on campus and everywhere else for that matter. I'm referring here to what is sometimes called, rather trivially, woke or cancel culture. This is a culture that developed rapidly in recent years, first in the United States and latterly in the UK. It's strongly identified with what's called identity politics, the idea that the world is to be seen through the prism of a variety of oppressions, most notably oppressions of race, sex, gender, and colonialization. And that those who suffer such oppression have a unique insight, a lived experience, so-called, that gives their views a truth and a power to count for more than the views of those who are taken to be oppressors. In this world, those who hold what is called white privilege, that is to say, all white people, however disadvantaged they may be economically and socially, are encouraged to become highly sensitive to their role in oppression and to take all steps to police their own behavior to eliminate its oppressive qualities. A good example of this is the way that language in the US and UK is now routinely screened for terms that might be offensive to one group or to another group. And the objections that are now taken, for example, to white authors writing Black characters into their novels without a Black lived experience. It said this is offensive and can't truly be done. Now here I want to take a little care. Much of what is often described, certainly in Western countries, as political correctness or wokeness is simply good and healthy progress. It's an unalloyed good. The ways in which people often express themselves in the past using derogatory or racist or sexist epithets, for example, are no longer acceptable. It's an unalloyed good that racism, sexism, and other forms of bigotry and discrimination are now seen as primitive and beyond the pale. It's an unalloyed good that we now have laws to protect people from discrimination and mistreatment, and that white people are thinking about the past and about their own behavior. These are healthy developments that have resulted from years of struggle on the part of oppressed people and a growing understanding on the part of the oppressors of the rights of, for example, women and people of color, and from the battles of people in all their diversity for space, safety, and liberation, including in their colleges and workplaces. And I think we need to be sensitive to the fact that speech can indeed be used as a tool of power. It can be used to oppress, to keep people in their place. This means that asking people who have historically been kept in a bad place to accept speech they see as intended to keep them in that bad place is no trivial thing. It's a very big ask. Some years ago, a Catholic professor in Oxford, a world-renowned legal philosopher, published a scholarly article that called into question the morality of homosexuality. When gay students protested, they were told by the university, don't seek to suppress his right to his opinion, instead, debate with him. Their reaction was, why should we have to debate with a professor to justify our existence? That's not a burden that's ever been placed on the professor abusing us. We shouldn't have to engage in a debate to justify who we are. Now, I think we should have some sympathy with this point of view. That's why universities have rules governing harassment and community conduct. Community rules requiring people to conduct themselves appropriately and to speak more or less respectfully are obviously appropriate and no threat to free speech. Equally, it's entirely appropriate, necessary even, to have rules to control and to prevent bullying. Certainly in the UK, all universities have these. But although this is not an entirely easy or comfortable conclusion, I think in the end, we have to accept that universities are places of ideas, or they are nothing. And that this notion must include, as the courts have repeatedly proclaimed, ideas that are genuinely shocking and genuinely offensive. We have to accept the possibility of meeting shock and offense in a university is an intrinsic part of being a member of a serious, inquiring institution. It's unavoidable if the university is to be true to itself. And so I think it's fundamentally worrying that a trend has developed in recent years in US and UK universities for taking the civilizing of language a stage further, so that the ideas behind the language are now routinely examined for their acceptability. Of course, to an extent, this has always been so. Fascist thinking, fascist ideas have long been taboo in the UK, including in UK universities. But these examples are extremes. And in the UK, the expression of nakedly fascist ideas would generally be caught by criminal laws prohibiting the incitement of hatred or incitement to violence. The difference now, and the problem now, I think, is that it's ideas that are really just unfashionable, controversial, or disconcerting to some people, however reasonably or politely expressed, that are being scrutinized and sometimes subject to constraint. In my university recently, there was an attempt by transgender activists to have a definition of transphobia adopted by the authorities that would render the expression of so-called gender-critical views subject to disciplinary action. So what are gender-critical views? Well, a gender-critical feminist is someone who argues that sex is real, and that people with male sex organs are not and cannot be women, however they describe themselves. So these transgender activists were arguing that a woman who argued that should be disciplined by the university authorities for expressing such a view. They should not be free to say it without sanction. They justified the definition they were contending for by arguing that gender-critical feminism, the expression of such views, was an attack on their identity as trans people and made them unsafe. They contended that men who identified with women were women and must be recognized as such by everyone, even if they had male sex organs. Not to believe this, they contended, was an act of phobia that should have consequences. Now, this and other arguments like it seem to me to stretch the concepts of identity and safety so far that they begin to encompass a supposed right on the part of people not to be confronted by ideas that they find offensive or uncomfortable. Of course, trans people are entitled to all the rights and protections that every other member of society enjoys, but this cannot be at the expense of the right of others within the law to express commonly held opinions. I believe that these are behaviors that sit ill in the university of all places. The university is not a place in which to retreat from the world in all its messiness. It's a place in which students should learn the opposite, how to engage with the world more critically, more intelligently. In the end, the university is not and should not be a place where, within the context of reasoned discourse and respect for rights, people are safe from having their ideas challenged. This is not a matter of political whim. It's a matter of human progress. In a lecture in 2018, Corey Staunton, then the legal director of the United Kingdom human rights organization Liberty, drew a comparison between two events at the University of California at Berkeley. One took place in October 1966, the other in April 2017. In 1966, the famous Black student activist and opponent of the Vietnam War named Stokely Carmichael was due to speak at Berkeley. The invitation that had been made to him was fiercely criticized by right-wing politicians, including by the then governor of California and later president of the United States, Ronald Reagan, who went so far as to threaten funding cuts to the university. As Carmichael spoke, he famously told his audience that free speech included the right for Black men to say what they wanted without first getting permission from white men. He didn't care that some people would be offended by what he had to say. He was going to say it anyway. To do so, particularly in the face of attempts to shut him down, was an act of liberation. Outside, as he spoke, right-wing protesters could be heard chanting abuse. 50 years later, in 2017, a right-wing internet troll named Milos Yiannopoulos was invited to speak at Berkeley by a right-wing student group. This time, the leftists protested, but once more the university stood firm and refused to cancel the event. However, on the day of Yiannopoulos' appearance, there was a near riot at Berkeley as the leftists sought to prevent him from speaking. This time, the protests were more successful and the event was disrupted as missiles were thrown, journalists' equipment was trashed, and bystanders were injured. Yiannopoulos himself fled. Cue protests from right-wing politicians, including President Trump, who unintentionally echoed the events of 1966 by threatening to cut off the university's funding. Now, Corey was not intending to equate Stokely Carmichael with Yiannopoulos. As she said, their speech was not of equal value. One was a thoughtful organizer and activist whose people, the Black people of the United States, had suffered centuries of violence, oppression, and deprivation of rights, including deprivation of their free speech rights. The other was an essentially trivial figure, a hard-right provocateur and poser whose whole business model lay in boosting his monetary profile by deliberately causing upset and offense to vulnerable and marginalized groups. But if Carmichael and Yiannopoulos were not of equal worth, their free speech rights were. And what these cases show is that a power to ban speech that offends you operates both ways. It'd be shocking, but perhaps accurate, to conclude that it was really only the balance of violence that determined in the end which of these speakers could open his mouth and which could not. Indeed, on the principle that too many appear to contend for today, that speech that offends should be shut down before it has the chance to cause distress, it could as easily have been Stokely Carmichael, the great civil rights activist who was silenced, and by the university itself. So while some people argue that the threat of so-called wokeness, of so-called cancel culture, is more imagined than real, that it's a complaint raised only by middle-aged white men like me perhaps, who fear they no longer enjoy cultural or media hegemony. I think this may be complacent. I think we do see in British and American universities a growing intolerance of dissent from the perceived correct view of the world. Gender-critical feminists, opponents of critical race theory, including leading Black academics, historians who examine the positives in war and empire. All these people, many of them serious and important thinkers, are not simply in danger of marginalization. They're in some danger of being written out, of being deleted from respectability in an increasingly censorious academy. I want to conclude with this. In 2018, in the face of these controversies, Timothy Garth-Nash, the leading historian of Europe, and I drafted a free speech policy for the University of Oxford. It's to be found now on the front page of the university's website and on the website of all the colleges of the university. I'll leave you with it because it summarizes my thinking as well as anything. So the University of Oxford's free speech statement reads as follows. Free speech is the lifeblood of a university. It enables the pursuit of knowledge. It helps us approach truth. It allows students, teachers, and researchers to become better acquainted with a variety of beliefs, theories, and opinions in the world. Recognizing the vital importance of free speech for the life of the mind, a university may make rules concerning the conduct of debate, but it should never prevent speech that is lawful. Inevitably, this will mean that some members of the University of Oxford are confronted with views that some may find unsettling, extreme, or offensive. The university must therefore foster freedom of expression within a framework of robust civility. Not all theories deserve equal respect. A university values expertise and intellectual achievement as well as openness. But within the bounds set by law, all voices or views which any member of our community considers relevant should be given the chance of a hearing. Wherever possible, they should also be exposed to evidence, questioning, and argument. As an integral part of this commitment to freedom of expression, we will take steps to ensure that all such exchanges happen peacefully. With appropriate regulation of the time, place, and manner of events, neither speakers nor listeners should have any reasonable grounds to feel intimidated or censored. It is this understanding of the central importance and specific roles of free speech in the university that guides the University of Oxford. Thank you all very much indeed. I hope I haven't taken too long, and I look forward to your questions.
At this point, if we were in person, we would hear loud applause. So on behalf of everyone, thank you so much, Lord Macdonald, for such a stimulating and very timely and engaging lecture. Lord Macdonald has kindly agreed to answer some questions. We have actually quite a number of them that some of you have already posted. I'm going to be selective in going through them, but if anyone else would like to ask further questions, do write them into the chat box. We have approximately 20 minutes for our Q&A. I'm going to read the questions that relate directly to your lecture, Lord Macdonald, first, and then if we have time, we'll come to the other ones. The first question is this. Do you think Prevent operates in universities to encourage or at least justify a culture of policing speech and suppressing supposedly offensive opinion, which extends far beyond the security parameter intended by the law?
I think with these sorts of programs, there's always a danger of what's called mission creep. So while it's true that the Prevent program is supposed to be directed towards identifying people who are in danger of falling into terrorism, therefore its parameters should be narrow, the risk is that it becomes much broader. Let me give you one example. I sat on the university's Prevent steering group, and we used to get a security briefing once a year from the local authorities. And this security briefing, when I attended my first meeting, went far beyond any issues of terrorism and talked about crime and disorder generally. And I took the view very, very strongly that this is precisely what we had to prevent from happening. The sense that the Prevent program would become a generalized surveillance program of students in all of their political activities. So yes, I think there is a risk of that. I think we managed to avoid it with a good deal of vigilance, but I'm not sure that all institutions have been as vigilant as we were. You know, if you give security authorities some power to intervene. It's in the nature of government institutions that once they accrue power, they try to accrue more. And mission creep is a real risk, I think, whenever you're bestowing power on security, intelligence, and law enforcement agencies.
Okay. The second question relates more to the latter part of your speech. It goes, why denigrate Milos versus Carmichael? A gay conservative speech is of no less value than a Black radical's. Preferring the ideas of one to the other should be no part of your assessment of their respective rights. I guess that's more of a comment.
Yeah, but that's exactly what I said. I said that there's free speech rights were equal. I personally, everyone's entitled to have a personal view. My view is that he is a trivial and offensive figure, and I think he's not a serious thinker or a serious activist. That's my personal view. But I absolutely accept that his free speech rights are equal to Stokely Carmichael's or to anyone else's, and I said that explicitly in my lecture.
Yeah. What do you think of the paradox of tolerance and how it would apply to the case of the transgender's call for the Oxford faculty member to be sanctioned?
Well, I think tolerance is part of what I'm not sure that I think that we should be asking people to be tolerant of things that they find offensive. I'm not sure that's the right word. I think it's perfectly acceptable for people to respond firmly and strongly to things that they find offensive, and to express their counter views strongly. So I wouldn't say this is so much about tolerance. I would say it's about recognizing that free speech rights attach to people whose views you disagree with. I mean, I may be playing with words here, but I don't really like tolerance in the context of this, because it sort of implies that you're telling people they ought to somehow accept the views that they find offensive. And I'm not arguing at all that people should accept those views. I'm not arguing at all that they should welcome them or incorporate them or anything else. They can find them completely offensive and completely reject them. What they can't do is say, you're not entitled to say that.
The next question is a short one. Would it be helpful to rename freedom of speech to freedom to offend? Make its meaning to those of a delicate constitution.
Yeah, well, I think freedom of speech incorporates with it, as the European cases I cited, the right to offend. I think there is a right to offend. There is certainly no right not to be offended. Let's put it that way.
Do you think universities should protect or resign faculty members, and maybe there's a typo there, protect faculty members based on the information or judgment in social media? It is not unusual these days to see that students' records and uploaded professors' words or videos online to raise high-profile topics.
Yeah, I think this is a real issue. I know that many academics find it difficult. I was on a website the other day, actually, so a US website called Rate My Professor, and you can go on it and people can post anonymously on this website, and they post anonymous reviews of their professors, the overwhelming majority of which, as far as I could see, were extremely abusive. He's useless, she's boring, they hadn't prepared properly, couldn't understand a word they were saying. I mean, it was. And I think if you're a professor, a hardworking professor, reading that sort of stuff from anonymous students, I think must be quite painful. I don't know how we deal with that. I mean, we're in a social media world. The University of Cambridge recently rolled out a tool for its students to report so-called microaggressions on the part of their professors anonymously to the university. A microaggression is a slight, a social slight, rolling your eyes when somebody speaks, or things of that sort, which are taken to be racist or sexist in origin. Students were given a tool to enable them to anonymously report their professors for this sort of behavior. There was such an outcry, I think rightly, that very swiftly this tool was withdrawn. But we're in a social media world, and I guess professors are going to be the victims of that as much as anyone else. For my own part, I don't engage in social media. I'm not on Twitter, I'm not on Facebook, and occasionally I know that occasionally when I've said or done things, there's been adverse comment on Twitter, but I never see it because I never look at Twitter. So what you don't see can't hurt you, is my philosophy on this. I just ignore it.
Okay, let's try this one. What do you think of oppressive language lists, which are now used by some universities and HR departments, which seek to encourage people to not use words which may be inadvertently offensive? One example is to avoid the use of the word slave and instead use enslaved person to show that slavery is an imposed condition rather than a classification of a person.
Yeah, I mean, as I said in my lecture, I do think that the process that we've seen in recent years of people being much more thoughtful about this, white people being more thoughtful about themselves and about their position in society, being more thoughtful about language. I don't think I don't have a problem with any of that, and I can quite see that language has rightly been modified in recent years, and there's some things that would have been said in the 1950s that would never be said now. Some expressions that we use would never be used now, and I think this is all good. This is just a question of human progress and emancipation, and I think it's to be welcomed. Of course, we can all find examples, and we sometimes see examples in newspapers of HR departments coming out with expressions that are totally bizarre. I mean, I know we all know about recent controversies of health authorities in the UK beginning to describe women as people with cervixes rather than women, because some transgender women who have male sex organs object to some of these other expressions. Breastfeeding is chest feeding. I mean, I think some of these new expressions and words are faddish and a bit foolish, but I think the general sense in which language has become more sensitive and more respectful in recent years is not a bad thing.
Okay. A question about the recent trend and phenomenon we see of monuments being taken down. What is your position on the demolition of statues of known slave traders in the UK, and the calls to pull down Confederate monuments in the US? Do we keep landmarks that might offend many people?
Yeah, I think it's impossible to give a general answer to this, actually, and it depends on the circumstances and context. One of the things that's quite interesting about a lot of those Confederate statues is that they put up in the late 19th century as a part of a kind of resurgence of white supremacist thinking in those parts of the United States at that time. So they don't date from the Civil War, even particularly shortly after it. So they're political contexts which always have to be considered and thought about. I mean, I must say I wouldn't be particularly comfortable myself in every day walking past a statue of someone who made their living from the slave trade and whose entire existence was around that. We have a window in the chapel of my college which commemorates a man who was Attorney General. He was an alumnus of my college, a lawyer, Attorney General of Jamaica, and in that guise devised new punishments for people who helped slaves to escape, and further more draconian punishments for enslaved people who were brought back into captivity. And then when he retired as Attorney General of Jamaica, returned to Parliament and argued strongly against abolition. He was an anti-abolitionist. And we took the decision to remove that window because he was a man whose whole life was based upon the enslaving of people and supporting that institution and in nourishing it and in doing everything that he could to see that it continued. And it seemed to us in a college, over 20% of whose students self-identified as being from Black or minority ethnic backgrounds, that was not appropriate. So I think it all depends on the circumstances. And I think this is a debate which is always going to be fraught because people will have different views about different statues, but I can quite see why it's appropriate that some statues are removed and appropriate where others might remain. So I don't think there's any yes or no answer to this, frankly.
A question closer to this part of the world. What do you think of academic freedom and freedom of speech at the universities within authoritarian settings? And the examples given of China, Myanmar, Cambodia, Russia.
Well, I've not been to Cambodia or Myanmar. I've been to China and Hong Kong many times, to both countries, and I've spoken in universities in China and Hong Kong many times. My observation in Hong Kong is that when I was visiting the University of Hong Kong, it was like visiting a university, a free university in any part of the world. It seemed to me to be a first-rank academic institution full of brilliant scholars where people were speaking perfectly freely. And I hope that remains the case. It's quite surprising when you visit universities. I think you get a false impression, a misleading impression to some extent. For example, I always found when I visited Chinese universities, though I haven't visited them so much under the present regime, my conversations with people in those universities were remarkably open about things like the death penalty, democracy, rule of law, and so on. I had very open discussions with Chinese legal scholars. We didn't agree about what the rule of law was at all, but we had very open discussions. So I think there has been in recent years, but perhaps not in very recent years, certainly in China, a kind of bit of a safe haven in some universities where fairly broad discussions were taking place. I honestly don't know whether that's still true, because although I was in Chengdu 2 years ago, I didn't have those sorts of, it wasn't the sort of visit where I was having those sorts of conversations with people. So I think it's possible for universities to remain, to an extent, oases in authoritarian regimes, but of course that's at the whim of the authorities. And if you run an authoritarian regime and you want to close down free speech in university, presumably you can do that quite easily. And as I said, I have no idea what the position is at the moment. I hope that the University of Hong Kong, and I hope and believe the University of Hong Kong remains as it was when I visited in the past, and I have seen nothing either tonight or in our conversations yesterday, Simon, to lead me to believe that it's changed dramatically.
Right. A question that takes us to Canada. Differentiating beliefs and identity is helpful, but in Quebec, the government is challenging language of speech and religious dress, two ways that blur your differentiation. Any thoughts?
Sorry, could you just, I need that, can you say that again? I think I'm sure I quite followed that.
Yeah. Differentiating beliefs and identity is helpful. But in Quebec, Canada, the government is challenging language of speech, the language of speech, and religious dress, two ways that blur your differentiation. Any thoughts?
Well, I don't entirely follow that, if what is being suggested is that people's dress in Quebec is being controlled in some way, then I'm just not familiar with that legislation or with the ways in which it's being done. And I don't want to sort of step into an area that I'm not at all familiar with. So I'm sorry, I don't think I can help with that.
All right, understood. The next question is, you suggest that religion and race are differently situated. Religion is a set of ideas that can be challenged or interrogated, whereas race is something immutable. What do you make of the argument that religion is not simply a set of ideas, but constitutive of one's identity, perhaps to a similar degree that one's race is? Would that suggest that insults to a person's religion should be treated in a similar way to insults to a person's race?
Yeah, I've heard that argument. I don't agree with it. And I understand that with religion comes not just a belief system, but a culture. And often people who are hostile towards people of religious belief are hostile to their culture. And I think this may be particularly true of Muslim people in the West. And I can see that's a problem, although I do think that the sort of activities which are feared in that respect are activities that would be unlawful under other laws. And in fact, I'm sure they are. So I don't accept it. And I'm not saying that I welcome people who are offensive about religious belief, or that it's something which we should encourage, or that it's something which we should just see as part of life. Obviously, people who are abusive of other people's religious belief, who are just rankly abusive, need to be remonstrated with, need to be confronted, need to be argued with. What I'm saying is that their right to say what they say should not be taken away from them, and that we cannot expect to live in a society where we're not confronted with this kind of behavior. And I think it is valid to make a distinction between people's identities as who they are in terms of their relation, their racial identity, and an identity which is formed around a set of beliefs. Because if you protect the latter, you're preventing people from questioning belief systems. And I just think that that's intolerable. You cannot, in a democratic society, prevent people from questioning belief systems. And when this legislation was going through Parliament, I was the Director of Public Prosecutions, and I had many groups approach me, people representing communities who wanted this legislation to prevent people from saying anything negative at all about their religion. They wanted a law which would prevent people from criticizing a religion. And I think this is a slippery slope to encourage people to believe that there is protection for belief systems, encourages people to believe that there's full protection for belief systems, and encourages people to believe that the state will intervene to protect belief systems from criticism. And I think that's a slippery slope, and I think it's a valid distinction, none of which is to encourage abusive or offensive language, but simply to say that in a free society, once you protect a belief system, there's no end to it.
Mm-hmm. The next question is, how should university respond regarding unlawful speech when the national security law outlaws even peaceful and non-violent speech and prohibits broadly defined secessionist and subversive speech?
Well, that's a very different situation, the situation that I'm used to in the UK. So our position in Oxford in relation to unlawful speech was that if we thought that someone was going to come into the college to speak unlawfully, let's suppose we thought someone was going to come into the college to make a speech that clearly was going to incite racial hatred, we would prohibit it because it's a criminal offence, and the college is finally a law-abiding institution and is not going to collude in the criminal law being broken. So if someone was going to come along to the college, for example, to make a speech encouraging people to go to join a terrorist group abroad, obviously we would prevent that from happening. If it did happen, and we had evidence of it, we'd report it to the police, because that's what law-abiding institutions do. That's the distinction with prevent, where under prevent we're being asked to police speech that wasn't unlawful. The situation in Hong Kong, I understand, is much more difficult, and it raises the question about the rule of law, isn't it? What is the rule of law? The rule of law isn't the rule of any old laws. I commend Lord Bingham's book on the rule of law. It's a short book, and it sums it all up very nicely. The rule of law doesn't mean the rule of any laws. It means the rule of laws that have democratic and due process legitimacy. If you live in a society where laws increasingly don't have democratic or due process legitimacy, then the situation, I can understand, is much more complicated and much more difficult.
There's a very long question, but I'm going to try to keep it brief. Why are medics and biotech specialists who are better qualified than government advisors prevented from debating and discussing the problems of vaccination? It refers to the BBC and other media have policies of not allowing this discourse. Do you have any views on that?
There's no policy the BBC has that I'm aware of that prevents medics from discussing vaccines. Every time I switch on the radio, there are discussions about the vaccination program and vaccines and vaccine hesitancy and the safety of vaccines. There is no such policy in the UK, or certainly no such policy on the BBC. There may be a policy of not broadcasting the views of known anti-vaxxers who are publishing notorious anti-vax propaganda, which is fantastical, conspiratorial, and untrue. But that's a different issue. That's a matter of public health and public safety. I'd be very surprised if a public broadcaster would give space to someone who said that 5G phone masks caused COVID, for example, or that a vaccination contains microchips put in there by Bill Gates, who's trying to take over people's minds. Of course, the BBC wouldn't give, no respectable news organization would give space to someone who's expressing those kinds of views. But there's no ban on scientists who are involved in developing vaccines from talking about vaccines. And there's been a lot of debate in our media about the correct approach to the pandemic, whether we should have a zero COVID policy such that you have in Hong Kong, or whether we should have a herd immunity policy, which is the policy that we're going for. These things are very widely and extensively debated, as are safety issues around vaccines. Safety issues around the Pfizer, around AstraZeneca are endlessly debated in the news media and the broadcast media. And there's no, if the implication of the question is there's been some censorship, I have to say I regard that as a conspiratorial view and unreflective of reality.
I think this would probably be the last question, and that is, how do you think what you have mentioned, which applies to university, would it apply to a university affiliated institution like an academic press?
Yeah, I think so. The University of Oxford Press is affiliated to the university. I think it's actually a department of the university, and I would expect its attitude towards academic freedom to be the same as the universities, because it's part of the university. Of course, some of the views that I've described as being offensive and crude and objectionable, but nevertheless capable of free speech exercise, are views that the University of Oxford Press wouldn't commission for a book because they're trashy views. I mean, if someone makes a deliberately offensive remark about Islam, for example, or holds very offensive views about Islam, it's moderately unlikely the University of Oxford Press is going to commission a book from them. First of all, because they're likely to be an idiot, and secondly, because there's no real intellectual coherence in a position of that sort. So, but I would expect the University of Oxford Press to be allied with the university's values when it comes to free speech and academic freedom.
I'm sorry, I have one more question.
Okay.
It's my own question.
Yeah.
I'm just curious if the UK universities have any policy about police coming onto the campus to enforce the law. That's of course something that we've seen here. I wonder.
Yeah, they do. The police. I've never seen the police on. We never had the police on. I was warden of Wadham College for 9 years. We never had the police in college. I think in Oxford, the position is that the police don't come into campus unless they're invited. And I'm not aware of any college in Oxford in my 9 years there ever inviting the police onto campus. I think it's most unlikely that would ever happen. I think the only circumstance in which it would happen is if there was some serious disorder, people attacking each other. I mean, if there was, it would never happen. We've had demonstrations, obviously, but the university has its own security, who are sort of civilian people who obviously are not armed and don't carry weapons or anything of that sort. They're not uniformed. And we have the college porters. If there were students, let's say we had a couple of students in the front quad who were drunk and shouting at each other, the porters would go and tell them to shut up and go back to their rooms. We would never call the police in. If there was a political demonstration, unless if there was a political demonstration and students started attacking college buildings and we were unable to control the situation internally, we first of all asked the university security to come. If they couldn't control it, then we probably would invite the police, but it's pretty unthinkable that would happen. I've never known it to happen. I think generally it would be very unusual in the UK for a university to call the police in, unless there was very serious disorder that the university felt that it couldn't control, and that certainly hasn't happened in living memory so far as I'm aware.
Well, I think we've reached our time. Well, thank you so much for covering so much ground and great diversity of questions. I really appreciate that. And let me just let everyone know that this is being recorded at the moment. And as with our usual practice, we will post the video of this lecture on the Hong Kong U website, and also I believe on the Boase, Cohen, Collins website as well. I think at this point, I'm now going to invite the Dean of our Faculty of Law, the Warren Chan Professor in Rights and Responsibilities, Professor Fu Wa-ling, to give the closing remarks.
Thank you, Simon.
Thank you. Thank you, Lord Macdonald, for this wonderful sharing. I was looking at the chat box, so I found the description of your talk, enlightening, stimulating, very thoughtful, insight for me. It's quite educational and very relevant to what's going on in Hong Kong. So it is not hard to say why the chambers and the partners, the directory, describe you as the senior statesman of the criminal law. So basically, the takeaway for me is two. First, probably prevent the program doesn't work for Hong Kong University. So normally we follow the practice of British institutions 5 or 10 years behind. So I hope prevent will not be replicated in Hong Kong. It is difficult to strike a balance between freedom and security. Well, different societies at different times may strike a different balance. I think there's one thing that everybody can agree upon. That is free speech is fundamental to the rule of law and financial centers like Hong Kong and London. So the free flow of information is, as what Lord Macdonald says, is the lifeblood, right? That would oxygenate our knowledge economies. So whatever balance is finally reached, it is essential that everyone can engage in speech that is free, but always respectful. So finally, let me thank your Lordship again for spending your time with us, sharing your knowledge. Thank Rachel for her supporting and for organizing the whole thing behind the scene. Simon for moderating the event. And our partner, both Cohen and Collins, for supporting the criminal law lectures. And of course, the ladies and gentlemen online who grace us with your presence. We will have future events, and we're looking forward to meeting you physically in Hong Kong University Faculty of Law campus. So on that, I thank you. Thanks.
So this concludes our fourth Boase, Cohen, Collins criminal law lecture. And thank you all for joining us. And as the Dean has said, we do hope to welcome you in person at the next lecture. Thank you very much. Have a good evening, everyone.